Embezzlement. Hey, we hear the term, but do we really know what it's all about? Well, let's take a look at a real case. It involves a woman who was working as an attorney in Virginia, and she was doing Social Security disability work. And she was working for a specific law firm. And she had an agreement with the law firm by which she would provide the representation. And when Social Security found in favor of her clients and sent her a check, she would give the check to the law firm because they, of course, were paying her for the work that she was doing. Little footnote to this, Social Security, when it makes payment of attorney's fees, will always make the check payable to a named attorney. They don't make it payable to a law firm. So if Susie Smith is the attorney working for Jones & Jones, the check is made payable to Susie Smith, even though it was Jones & Jones who was employing Susie Smith. Okay, well, in this instance, this attorney, this female attorney, unfortunately for her, began to take some of these checks and deposit them in her own checking account. Well, the firm found out about this, and they found out that over the years she had been there, she had deposited $400,000 worth of attorney's fees in her own account. They weren't pleased with this. They sued her for that amount of money, but in addition turned her over to the DA's office. DA said, you know what? You are being charged with embezzlement. You're being charged with taking funds that belong to your employer and turning them to your own purpose. She, in her defense, through her criminal attorney, said, wait a second. What I did was wrong. And yes, I do need to repay my employer, and I'm in the process of doing that right now. Under my employment agreement, I have an obligation to pay him. I understand that. But you know what? You, the state of Virginia, do not have a case against me in criminal law because I did not steal from my employer. The checks I got were made payable to me. They weren't made payable to my law firm. They were made payable to me. And when I got those, I could deposit them in my own account. And you know what? I didn't get those from Social Security to hold in trust for my employer. I got them directly from Social Security, and I could do what I want with them. I did not have any obligation to give that money to them except under the employment contract that I had. But the checks were payable to me. Well, the case was heard, and again, went up to the Virginia Supreme Court. There, the Virginia Supreme Court heard these arguments, and they said, well, all right, we understand this. We understand the check was payable to you. We also understand that you've agreed to repay the money under your employment agreement under civil law. But here we're dealing with criminal law, and here we're dealing with the act of embezzlement, taking the funds of an employer. And here what we find is that even though the Social Security Administration did not pay this money to you to hold in trust for your employer, the fact is that it was paid to you, and under the agreement you had with your employer, you had an obligation to pay your employer. So at the time you received those monies, those checks, they essentially already belonged to your employer, and you had an obligation to give it to your employer. When you did not, you took money from your employer, you engaged in the act of embezzlement, and accordingly the conviction can stand. Okay, so what do we learn from this? What do we learn from this? What we learn is that sometimes in everyday activities, may not necessarily work as an attorney or in some other position, but if you're in a position of trust as a bank teller or anybody else that receives money given to you, if you are doing that in the course and scope of your employment, it's generally understood that money doesn't belong to you, it belongs to your employer. And think about this, when you shove money, cash, across the counter at a bank, giving it to a bank teller, you're not giving it to the bank teller for her use or his use, you're giving it to the bank. That person is an employee of the bank, and when they receive that money, they receive it as an employee of the bank. They receive it in trust for the bank. All right, there are many instances in which that can happen. A lot of times when people use vehicles, whether commercial vehicles, sometimes whether Personal automobiles that are given to them by an employer for use, that still belongs to the employer. Use of those for personal purposes can result in a charge of embezzlement unless, of course, there was an agreement dealing with that. As long as the property is deemed to belong to the employer, it belongs to the employer. Okay. We bring you this case, as we bring you cases every week, so you understand how the law works. I'm David Allen.